Hello, it's Philip Taylor speaking from Richmond Green Chambers. This morning I'm looking at a book from Edward Elgar Publishing Limited, an independent family publishers. It's called Private Enforcement of Antitrust Law in the United States, a Handbook. And it's been edited by Albert A. Foer and Randy M. Stutz. It's an important book because we have a different term for antitrust law. We call it competition law in its widest sense, and please don't take the tags too literally. What we're saying here, though, is that this book is a strategic book for transatlantic law firms involved in antitrust matters, because whatever the flavour and the terms we use, it's still the same basic issue that we are looking at and trying to advise on. Antitrust violation causes widespread harm. That is a fact, whether one likes it or not. Therefore, the book examines the methods of redressing such harms in the American context by private individuals and or organisations rather than government agencies. In other words, your civil redress without bringing the state heavies in, if I can put it that way. The book by Albert Foer and Randy Stutz, which, as the title indicates, has been prepared for the American market, focuses on an incredibly broad range of antitrust issues, which in the United Kingdom we would consider similar in terms of policy to mergers and acquisitions, for instance, and basically the concepts which we have for competition law and all of the rigmarole that goes with EU membership too. It's been prepared in association with the Washington DC based American Antitrust Institute, and the book is actually a collection of learned essays and articles by no less than 34 prominent US practitioners specialising in this field. And bearing in mind that regardless of differences in the legal landscape between the US and UK, the book will undoubtedly interest UK practitioners, if only because the corporate problems that occur in antitrust matters and the issues raised as a result are remarkably similar, regardless of whether they emerge on one side of the Atlantic or the other. One of the distinguishing features of the book is that it's suitable, not to mention enlightening, for both experienced and inexperienced practitioners alike, as well as, say, academics, students and government officials. Whether novice or expert in the field, then, fans of John Grisham novels will recognise the mighty reach of the class action referred to as Rule 23. Interestingly, the editors mention at least two recent cases, including the one involving Walmart, that threaten to fundamentally alter the use of the class action, which has been, in their words, the primary procedural mechanism for the private redress of widespread harm caused by antitrust violations. And following Professor Land's introduction on the benefits of private enforcement, the book's ensuing 15 chapters examine in more or less chronological order a variety of issues. This is the book, that's what it looks like, and there's the back of it. It's got a useful index, and you can see that the structure, huge amount of footnoting going on, lots of paragraph numbering to find things. I'm really delighted with this book. I think it's a very useful contribution. You can see the contents are at the front there. It's a very useful contribution to the continuing debate. I'd like to thank everybody concerned for producing it, and I think it adds a great deal to what is a perennial problem for all of us. Thank you. Bye-bye.